Now, the Thomson Reuters case I was at last week is really interesting because this was a legal firm that publishes legal information, and one of its employees opened a competing firm called Ross Intelligence. Now, what they did was they knew they wanted to get some of the content to train their large language models. So they said, where do we buy it? So they went to Westlaw, which is the company that Reuters owns in the legal circles, and they asked to license it, and they were turned down. Now, they didn't want to give up theirs, so they did something that was really smart and an end around and something that is constantly done, including by ChatGPT and all the others. They buy the data from what are called third parties. So in this case, there was a company called Legalese who has third-party data, all good. So they bought what were called Westlaw's head notes. Think of them like cliff notes for legal cases, which summarize these really intense cases. And they ordered this, as in legal circles are called bulk memos. Give us a set of really good arguments for this case and a really bad set of arguments, sort of the spectrum. So by ordering this through Legalese, they were able to get it from Westlaw, and they published it to train their own database, basically, about 25,000 articles. Now, this is such an eerie comparison to what happened to OpenAI, to Anthropic, to Stability. All of them went to buy data, and pretty much all of them would use third parties. One was called Common Crawl. They have crawled the internet for years. No one really cares. We all sort of gave our permission without knowing. And it really wasn't making a lot of money. There really wasn't that big a deal. But now these companies with billions of dollars go in and buy all this information and this copyright. Now it seems to matter because they're going to generate hundreds of billions, trillions of dollars. So all that content was used to fuel it. But in Thomson Reuters' case, the judge found and actually admitted that sometimes the best wisdom is reviewing what you've said. A federal judge found for Thomson Reuters in what's called summary judgment and said that Ross did not have the right to buy these because the head notes were copyrightable. Now, those head notes came out of an AI content, but they were also human managed. The judge noticed that the decision making, the important things that apply to that case are all in the head notes. So there was a copyrightable compilation. For those who followed my podcast, think Zarya the Dawn again. They love those compilations with AI. That compilation was copyrightable. So Thomson Reuters actually is proof that you can have AI content, or at least content on an AI platform, and if it's put in another person's platform who bought it, supposedly legally, that's not allowed. That's a copyright infringement, and they'll have to take it off. So what we found was that the practice that a lot of the companies did in AI to get their data, a common practice in Silicon Valley. Everybody buys third-party data. It's the end around. No blocks, no regulations. Third parties rarely have rules. These other companies do. So they bought the data and they put it in. But if you compare that to the trillions and trillions of records, images, words downloaded from the internet by OpenAI, by Anthropic, by all of them, it pales in comparison. It doesn't even make sense. If we look at that, then there is a reason to believe that that content really does have a standing for copyright. And if that does, and if the U.S. Copyright Office somehow goes totally rogue and says there's a liability and compensation due for what went in, then we have about 5 years of data to talk about. Now, I don't really think it's likely to happen, but this is the importance of copyright in what we're talking about. And before we go in, I want to take a little origin story of the Constitution, the U.S. Constitution, which defined the original ideas behind copyright, which weren't done to protect individual rights necessarily. It was also done to encourage, like patents, that this information gets out to the public domain. So let's look at the rules and the wording and what the Copyright Office is trying to do to fulfill a 1787 rule about AI-generated content. Yeah. Even Thomas Jefferson, as smart as he was, couldn't twist his head around what's going on. But hey, he hadn't seen a camera.